Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled State of Vermont versus J. Orost, case number 23 AP 345. Representing the appellant, J. Orost, is John Matthews. Representing the appellee, State of Vermont, is Evan Meenan.
Thanks very much. Counsel, come on up if you would, please. And before you start, introduce yourself, identify your client, then proceed.
Great. I'm John Matthews, and I represent Jay Orost, the appellant in this matter.
Thank you.
Jay Orost was arrested in October of 2017, and he was sentenced in October of 2023. Because of the nature of the charges in this case, the size of the community, and the amount of time that it took, it was incumbent upon the trial court to take particular care with the jury pool, the evidentiary rulings, and the jury instructions. In each of these phases, the trial court erred. Mr. Orost has a constitutional right to a trial by an impartial jury. And it's the role of the courts to safeguard that right by excluding from the jury persons who evince bias against the defendant. With respect to three different jurors, and in particular, Juror Bilodeau, the court did not do so when it did not remove Bilodeau.
How so? How so?
How so?
You're probably just about to say it. So,
First, it's worth mentioning that this case, as it went on over the course of the 6 years, one of the key evidentiary issues in the case had to do with, there were maybe 12 different motions filed between the two parties about what kind of evidence of prior bad acts was going to come in and what was not going to come in, or what couldn't come in, or what was too prejudicial. And there was a lot of litigation done around those issues. And in fact, three different judges made rulings on those issues. And one of the key facts was that Mr. Orost was married to his adoptive daughter. So the adoptive daughter he married, and they had 4 children together. And the complainant in this case, or one of the complainants in this case, was his biological daughter. And it was ruled by Judge Schaefritz and then also Judge Waples that information that he had married his adoptive daughter was not to come into the case. But there was a great fear on the part of the defense, and rightly so, that information would be super prejudicial, and it was something that should be kept out. It ultimately was kept out of the trial, but when they were drawing the jury,
that he had married the adopted daughter?
He had married the adopted daughter.
That was kept out.
That was kept out. But there was
by order of the court.
By order of the court, correct. Yeah. That was the ruling by all of the judges who considered it. But when they were drawing the jury, first it was during COVID, and so there were a number of jury questionnaires that were done. And then when the jurors...
was it a virtual jury draw?
Say that?
Was it a virtual jury draw?
It was not a virtual jury draw, Your Honor. But there was a lengthy questionnaire, and there were certain jurors that were eliminated simply on the basis of, I Googled it, or I knew this, or I knew that. So then when the jurors came in, Juror Bilodeau said, well, I need to talk to you because I work at Global Foundries, and that's where Mr. Orost had worked. And he said, I actually supervise the section that Mr. Orost used to work in. I overlapped with him there a little bit, but not extensively. He wasn't his direct supervisor.
Matthews, didn't he specifically say that all he knew was that he had at some point worked there? He was told by someone else, that guy worked here. He didn't know anything else about it.
I don't think so, Your Honor. I think that what he said was he had seen him in the halls and stuff. And then when he took over the unit, he realized when he went to go to the jury draw, he said to his supervisor, I have jury duty. And he said, oh, you realize that guy, he worked in this section.
He didn't know, he said he didn't know anything else about it. And didn't the judge every day ask if there was anything anybody had realized or needed to mention, and nobody ever responded? So isn't it pure speculation that he would have known anything else?
Well, No, because he also said, and this is in the jury draw transcript from pages like 198 to 212. But what he said was, my wife grew up with Jay Orost, and she followed this case very closely. And what he said was, I know that it's a case, it's a sexual assault. I know it involves children. I know it involved children in our area. And the court said, well, do you really know? And he said, well, I'm not sure what I remember about it, but my wife followed it very closely, is what he said, because she had known Mr. Orost growing up. So
Isn't that the same, though, as a person who maybe read something about a case in the newspaper and hears what the case is about, who's involved, but then comes to jury draw and says, I haven't made any determinations in my mind about guilt or innocence or anything? Does it matter that it came from his wife as opposed to reading in the newspaper?
Not necessarily, but what does matter is that he said that his wife followed it very closely, and that because she knew somebody involved, and there were coworkers that he interacted with. And he said also in this 12 pages that it would be awkward for him to sit on the case. And most importantly, though, is that he said, I don't know what I would be reminded of when I started to hear the details of the case. I really don't remember it because I know my wife was following it. I know she told me about it. And I now know that if I'm going to be called, he said, I've been a jury person before. I've been a foreman before, and I would feel very hesitant to be the foreperson of this jury.
What do you say about this Hanman case? I don't know if I'm pronouncing it correctly. You know about that case? It's an older case. And we said there, we said
Sure.
that there's a distinction between knowledge and bias.
That's true. And there's some overlap, though, in this case between, I agree with you, and this is a little bit of a hybrid between knowledge and bias, because it, similar to the case involving the Turner versus the Catholic Archdiocese, in that case, this court said that a person who was a member of the diocese and who and was a parishioner there, and who had heard from
Right.
her priest that this could really bankrupt the church, was somebody who should have been eliminated for cause, right? And in this case, it's
But
not.
I think the court talked about how close the relationship was there. So that there was, I think, this is in my notes, so I'm not
Sure.
reading from the case, but I think I wrote it down as it is reflected in the case that bias may be inferred based upon the closeness of the relationship. So, was that here?
So, Your Honor, I would agree with you that there is a difference between knowledge and bias, and that in that what they were talking about in this case, Turner, and also in Holman earlier, was the relationship of the person to the church or to the bishop, or the relationship of a person whose doctor is on trial. And in this case, it's a little bit that, it's a little bit his role as a coworker, but it's.
But is it enough? And if so, why is it enough? If that, I assume
Well,
that's your point.
it's enough because in this case, it goes to the other thing that you asked about, which is knowledge, right?
Right.
The main concern here was that this trial was happening 5 years later. There had been media reports. This was a person who, the wife was a school board member. There were several children in the schools. There were they were members of the church, and there was a real concern about this particular fact about him being married to his wife, who had been who was his adopted child, and there were allegations of sexual abuse against him from her and her sister.
So in a jury draw, the trial court's observing the jurors, watching the interaction between the attorneys and the juror, and listening to the responses. And isn't the trial judge in the best position to make a determination of whether or not it's a challenge for cause or the need for a parameter?
The trial court judge is probably in the best position to do that. But I think in this case, because of the circumstances, the trial court made the wrong decision. And I think that the part of the reason that they erred in this way is because it was during COVID and because they were worried about having enough jurors. And the judge, the judge should have erred on the side of caution in this case because there was a very real concern that he would get there into the box and he would be reminded of these things that he knew about the case that either his wife had told him or that he knew from work, or that he would feel somewhat intimidated about work. I mean, he said that when he told his boss, his eyes popped out and they realized it was taboo.
Is there any indication that he actually ever was reminded of anything that he shouldn't have been reminded of?
Well, we can't know that, Justice Eaton, because because he was eliminated with peremptory. So what we have is these 15 pages where he says, I feel awkward. I felt like this was a miss. But no, we don't have any indication that he.
Your claim is that because he had to use the peremptory, counsel then didn't get to strike someone else.
That's
And
correct.
what was the concern about that other person? Is it Morse? Is that
It was Morse, but it doesn't matter what the concern about that other person was because he preserved his objection by, he preserved the objection simply by making it, clarifying it, and then using all of his peremptory.
So he used all 8 of his peremptories. Had he not used 8, then there'd be no issue regarding this juror, correct?
That's absolutely right. Right.
And
But
the
it
fact-
doesn't matter we don't have to consider Morse or whether Morse should have, that isn't relevant to the consideration. He did what he needed to do by preserving.
Even if he had removed him for the juror for the express purpose of being able to exhaust the peremptories, that would have been fine. He said he doesn't have to give a reason.
He doesn't, he just has to exhaust.
Just has to exhaust, and that's what he was doing.
That's what he did. That's correct. If there are no further questions, I'll reserve the rest.
Okay, thanks. We'll hear from counsel for the appellee, please, coming up. And before you start, so move the rocket ship up if you want to. Is that as high as it'll go? Is that right?
This is as high as it will go, but please, if anybody has problems hearing me, just let me know.
No, I don't think we do. But for the record, would you introduce yourself and identify your client, please?
Absolutely. My name is Evan Neenan, and I represent the state of Vermont, which in this case is respectfully asking the court to affirm appellant's convictions for sexually abusing his daughter and his daughter's friends. With respect to the jury selection issues, it's the state's position that the court did not abuse its discretion in refusing to dismiss 3 jurors. And there's 2 legal principles that I think are very important to view appellant's arguments through. And those principles, I think, were hinted at by Justice Cohen when he asked, isn't the trial court really in the best position to make these types of determinations? And those legal principles, the first one comes from Sherrill, in which this court said, there are a few aspects of a jury trial where this court would be less inclined to disturb a trial court's exercise of discretion, absent clear abuse, than in ruling on challenges for cause and impaneling a jury.
Has there been a case in Vermont where there was a reversal on that issue?
Not one that's coming to mind right now, but based on the facts in this case, I don't think that this case would be such an instance in which the trial court's discretion should be overruled. And I think that, part of that relates to the second legal principle, but also a point that Judge Torr made. That second legal principle comes from Swain and states that once the jury is impaneled, the jury presumes every juror sitting on the case is indifferent and above legal exception. And the point that I believe Judge Torr made was that appellant's arguments to the contrary really are unpersuasive factually because they presume that jurors Tilton and Bellato, I believe I'm pronouncing their names correctly, knew that appellant had married his his adopted daughter, and they speculate that those 2 jurors heard something that might have triggered that knowledge. Neither that presumption nor that speculation is supported by the record in this case. In fact, the record in this case directly rebuts that presumption and speculation because both of the jurors confirmed that they could be fair and impartial despite any prior knowledge of the Orost family. Specifically regarding jury Bellato, on which Appellant focused in his oral argument, he did acknowledge that he knew the defendant through work, but not directly. I don't believe that the record supports that he ever actually worked with him, just that he, at the time of jury draw, was supervising the same division in which the appellant worked. He did acknowledge that it might be awkward for him to sit on the jury, but he was very clear that that wouldn't prevent him from being fair and impartial. He also stated that he knew vaguely about the nature of the charges, but he didn't know, quote, any of the specifics, and quote, I couldn't tell you what went on. He also confirmed, like all of the other jurors who were allowed to sit in this case, that they would be able to decide the case on the evidence presented. In other words, they confirmed what this court presumes, that all of the jurors would follow the jury instructions to base their decision only on the evidence that was presented, and the definition of the evidence was provided to them by the court, and that they were not to consider any information that they might have obtained outside of the courtroom, including before trial, such as, for example, from their spouses.
Mr. Mayor, can we jump to another issue, the one about the contracts and the prenup
Yes,
that were admitted in this case? Can
absolutely.
you tell me why those were really relevant to anything and why you argue that they were not more prejudicial than probative?
Absolutely. So I would like to start off answering your question by emphasizing a point which I know this court is aware of. That under Rule of Evidence 403, evidence that is prejudicial isn't automatically excluded. It has to be unfairly prejudicial, which means that its primary purpose is to invite or cause the jury to decide the case based on something other than the evidence presented, such as.
That was, weren't those really just to show what a disgusting person this was?
Oh, absolutely not, Your Honor. Turning to the marital agreement first, the state's position is that the introduction of that agreement was not unfairly prejudicial because its primary purpose was not to trigger undue sympathy by the jury, but instead to establish the degree of control that appellant asserted over Katie Orost. And that control was relevant in this case because it caused Katie's delayed disclosure of appellant's incriminating statements. It caused her to try and help appellant convince KO to recant. And it rebutted appellant's argument that Katie changed her testimony because of immunity that she allegedly received from the state. Notably, it's clear that the court exercised its discretion in ruling on the admissibility of that agreement because it took the time to redact a portion of it, specifically a paragraph that dealt with allegations of domestic assault. So we know that there was an exercise of discretion, and the record establishes that the primary purpose of the state introducing that evidence wasn't for an impermissible purpose. The same is true with regard to the dating contracts. They were not unfairly prejudicial because the primary purpose was to establish the degree of control that the appellant asserted over KO and AS. That control was also relevant because it impacted how and when both of those young individuals disclosed the abuse that was perpetrated upon them. And as argued below, I think the phrases that the state used to articulate why they are relevant was that it evidenced the defendant's manipulative and controlling behavior designed to perpetrate his victimization of these individuals and also to show his plan and intent to carry on that abuse for an extended period of time. And we know in this case that it did go on for an extended period of time. I believe AS even indicated that one of the reasons why she continued to go over to the Orost family was because she felt like she was part of the family. And if she was there, she could help protect both KO and some of the other children. That feeling, being part of the family, the state would assert, is partly the result of the appellant's controlling behavior. So both of those pieces of evidence were relevant to explain how it is that the appellant was able to perpetrate this type of abuse for such an extended period of time on two young girls without them making any disclosures for such a long period of time. I think I would like to turn back to the absent additional questions, turn back to the jury selection process, because that was the emphasis of the appellant's argument. And there was some conversation as a result of your questions, Justice Reiber, about the types of bias that can result in disqualification. And this court has recognized two types of bias, both fixed bias and implied bias. Only when one of those two types of bias is present is the exclusion of a juror for cause appropriate. Now, fixed bias only exists when a juror, quote, evinces a state of mind inconsistent with deciding the case fairly. In other words, when the juror states he may have trouble putting aside prejudices and making a decision based only on the evidence and applying a burden of proof or law consistent with the court's instructions. All of the jurors in this case indicated that they would be able to follow the court's instructions to do that very thing. And as I mentioned earlier, this court presumes that jurors follow instructions. As a result, as Chief Justice Reiber also noted, any knowledge that they may have had about this case is distinct from whether or not they had any type of fixed bias.
Mr. Manning, can we change gears just a little bit? I don't mean to take
Yes.
you off that issue, but to talk about the jury charge just
Yes.
a little bit regarding the assertion that parts of the elements of the case were directed by the trial court.
Absolutely.
And what's the response from the state on that?
So I believe the appellant's argument related to that issue deals with the prefatory language that appeared for each of the counts that were included in the jury instructions. And it's the state's position that that prefatory language did not impermissibly comment on the evidence or a direct verdict in this particular case. And that's primarily for two reasons. The first reason is that prefatory language that appellant complains of was actually just a recitation of a portion of the charging language from the state's information. And it was clear from the context in which that prefatory language occurred that what the court was doing was explaining to them, the jurors that is, what the nature of the charge was. And the second reason why the court did not effectively direct verdict for the state was because later on in the instructions, it clearly told the jury that whether KO was under 18 and whether she was the appellant's child and or entrusted into his care were two separate elements of the offense, and that the state had to prove those elements beyond a reasonable doubt.
Was it confusing in any way regarding the language that was used by the court and then explaining what elements needed to be proven beyond a reasonable doubt as the second part of that?
This is the state's position that no, it was not confusing. And in fact, the overall structure of the jury instructions is not uncommon in the state of Vermont, where first the jury is told this is what the defendant is charged with committing. And usually it's a recitation or a fairly close recitation of the charging language itself. In other words, the court is informing the jurors, this is what the state has charged the defendant with. And then the state will say, okay, let's take a deeper look into that. Here are the specific elements of that offense. And the court in this particular case said, one element was that KO was under 18, and another element was that she was either the appellant's child or she was entrusted to his care. And both of those elements must be proved beyond a reasonable doubt. And it's the state's burden to prove them. So no, the state's position is that they were not confusing and that the jury had adequate instructions consistent with this court's recognition that really the test is whether or not the instructions as a whole were misleading or inadequate. So we have to look at the instruction as a whole. By focusing in on just the prefatory language, appellant is effectively ignoring that case law and is trying to cherry pick one particular phrase to say, I should be entitled to a new trial. The state's position is that that's not the way in which this court goes about reviewing jury instructions. The state has similar arguments with regard to defendants' complaints about the definition of sexual act. The appellant is asserting that it was impermissibly broad. The state's assertion is that yes, there is some recognition by this court, for example, in the Stevens case, that it would be better practice to only state what the specific allegation is in the charge. However, just because something is better practice does not necessarily mean it constitutes reversible error. And this court has other cases, such as Mott and Letourneau, which the state discusses in its brief, that recognizes when a jury instruction follows statutory language, that's not reversible error. And that's what the court did in this case. It used the entirety of the definition of sexual act. However, it was clear when it was informing the jury what the state's specific allegations were, what particular sexual act was at issue for each of the counts where that definition was involved. I see I might have a little bit of time left, and I'm happy to cede that time unless there's additional questions.
Okay.
Thank you.
That's it. Thank you very much. How much time do you have?
Appellant has 3 minutes, 35 seconds remaining.
Counsel.
Before I start telling you what I've been sitting there getting ready to say, why don't I ask if there are issues you're interested in and you would like me to address? If anyone has a question before I start,
I do. What's the issue on the photo array? Why is that a contentious issue here? This is what they look like at a certain period in their lives, and it correlates with the time of the alleged acts.
But it's not necessarily relevant to what was done to the kids or what was allegedly done to the kids. It's not necessary to see a photo. It was only offered to inflame the jury or to inflame the fact finder about they're this age or that age. Both the complainants testified well, they testified thoughtfully, they remembered, they could say the ages that they were. So there's only one reason to enter photographs of children at different ages, which is to highlight and inflame the passions of the jury. I think the same was true of the picture of the vulva that they were asked to point to. Again, both of these women were well-spoken, they were thoughtful, they knew how to use words. It wasn't a child who needed to point to something in order to show a word that they were not comfortable using. In this situation, both complainants were perfectly able to explain the relevant evidence. And so these photographs were really irrelevant and I think generally meant to inflame.
Right, thank you.
Ms. Matthews, regarding the jury instruction, taking the instruction as a whole, that's what we're supposed to do, or the trial court instructs the jury to do. Isn't it clear in the instruction that the state had the burden to prove that the child was over 18 and that was within the control of the defendant?
Well, Your Honor, I don't think so. The way that the charge was stated was charge 1 and charge 2 charged the same type of crime of sexual assault against KO 17, who was under the age of 18 years old and who is Mr. Orost's child. And that's the beginning language. Now they do go through and say that the court then stated the elements of the charge and they gave an expansive definition as counsel for the appellee alluded of sexual assault that was, or what sexual assault would be that was broader than it should have been. And generally speaking, when the jurors pay attention to the things that the judge says. So when the judge says KO, who was under 18 years old and who was Mr. Orost's child, I do think it's at least confusing.
So is it suggestive? Is it suggesting that the fact that it's That's an
I
undisputed-
believe it was directing the verdict because of the way it was stated. It was the way the charge was read. The court was telling them, you don't really need to find that because she's the daughter and she's under 18 years of age.
Did anyone contest those facts, though?
Well, what happened is the defense counsel said, do we have to have that language? I don't like that continuing to refer as the child. Let's keep the entrustment language that tracks the statute. And the court said, but isn't it obvious? That's what it is here. So yes, arguably defense counsel did object.
Okay, your time has expired. Thank you very much. Please call the conclusion of the hearing.
That concludes today's